Well, I just don't see how her status as a mayor in an organization related to mayors suspends her role as mayor.
Okay, I believe we're ready to go. The Second Judicial District Court is now back in session.
Thank you very much. Appreciate everybody's time in this. Mr. McElhinney, can you continue, sir?
Request number 7, Dr. Conrad, please let's take a look at that. As I understand, you received those records on time. Is that correct? Or within the proposed time limit that the city gave you?
I believe so.
Okay. And again, as with the previous body cam footage, they initially sent you an invoice, which you did not have to pay, correct?
Which initial one? From 2020?
No, the other body worn camera request that you made where they charged you. I understand they charged you on 2 separate occasions, and on neither you had to pay. Is that correct?
I believe the first case was in 2019 or 2020. 2019, I believe.
Okay.
And I did pay, and then after I had to hire legal counsel, and after that letter, that exhibit 22 was sent, then I did get a refund on that.
Okay. Okay.
So it's not quite accurate to say that I didn't pay, because I technically did, and then had to get a refund after I had to hire an attorney. So I did pay it, but then I got it refunded.
Okay. So you weren't out of pocket for any body cam footage, correct?
Ultimately, no.
Okay. Okay, so let's move on to request number 9. And this is going to be Councilmember Reese's social media.
Sorry, I was getting a phone call.
Yeah, thank you, Dr. Conrad. Please turn that off during the course of this hearing.
All right, hold on 1 second. It's part of my system. I don't know how to. My phone rings, computer lights up. I don't know how to change that. I'm sorry.
Okay, Dr. Conrad. So hopefully we don't get another one. I appreciate that.
Yeah, thank you. Sorry about that.
Okay, so Dr. Conrad, I'll direct you additionally to Exhibit 11.
Okay.
And is it your position, sir, that and I'm going to use words or language straight from case law, the Blackjack Building case, is it your position that these messages represent provisions of public service?
You're asking specifically about exhibit number 11?
Correct.
Well, yeah, I mean, here is a publicly elected official opining on his position in a public forum. So, yes.
And in your mind, that is the provision of a public service?
Yes.
Okay. Is there any specific, like a buzzword in there that leads you to that conclusion? Like what service is he providing specifically?
So if you look at the first line of that tweet, it literally mentions the word public engagement, being responsive, quote, in a variety of mediums, 24/7. So
that sounds like a definition of public engagement. Would you disagree with that?
No.
Okay. Okay, let's move on to, let's see. Shoot, Mr. Busby, can you refresh my memory which exhibit is his more extensive, Mr. Reese's more extensive messages?
It's exhibit 27, right?
27. Well, that's his affidavit. There's more. This is one of your exhibits.
I'm sorry, there's Exhibit 21 and Exhibit 23, which are the declarations from our witnesses.
Understood. Okay, Dr. Conrad, same questions here with regard to Exhibit 21. Is it your position that these messages are provisions of public service by way of Councilmember Reese?
Yes.
Okay. And can you cite to any of these specific messages that lead you to that? What kind of service is he providing, and what kind of city business is he discussing?
Well, I believe the entire thread is related to city business. He's talking about the Access Advisory Committee, the issue of bird scooters, so on and so forth.
Is he deliberating or making any kind of decisions in these messages that you can tell?
I don't know how you would define deliberating. He's asking questions. That could be considered maybe a deliberation.
Okay. Now, what about
communicating directly with a constituent? I mean, I guess that could be considered deliberating, perhaps.
Mm-hmm. Okay. Are you well, not aware, but can you appreciate that council members have the right to private speech in certain contexts? Do you understand that?
I understand. Yes, I understand what you just said.
Okay. And when they're conducting that private speech on their private device, meaning not a city-owned device, they're free to speak about almost anything that's not action or deliberation on city business. Would you agree with that?
No, object. Calls for legal conclusion.
Sustained.
I'll rephrase. No, I'll withdraw it. Okay, let's move on to request number 10, the space whale, please. Now, Dr. Conrad, as I understand, the response from the City of Reno pursuant to this request was not a denial, but it was a response that we don't have any of these records under our custody and control. Is that correct?
I don't know if custody and control was ever mentioned. I mean,
Okay.
if the mayor was in possession of them, that would imply, I would believe that would imply she has custody of it. She was handing them out, or somebody was handing them out on her behalf to all of the mayors. So at some point, somebody at the city would have had some kind of input on this.
Are you speculating, or do you have evidence to support that?
The evidence is in the video where she announced that she was giving away, unless she was just lying and didn't do it.
Okay, so you disagree with the premise that the mayor was not acting in her capacity as mayor of the city of Reno. She was acting as vice president of the mayor's conference. Do you disagree with that?
Well, I just don't see how her status as a mayor in an organization related to mayors suspends her role as mayor.
Well, I guess, I'm not asking you whether her role was suspended, but when she's acting as the mayor, she is conducting city business. Would you disagree with that?
Well, I mean, the mayor does all sorts of things, symbolic, appearances and so on and so forth. And it's assumed because of the nature of her position that she's doing that in her capacity. And I think clearly in this case, she was acting in her capacity as mayor. That's what the name of the conference was.
Understood.
That's what the name of the organization is.
Right, but is there any evidence? Do you have any evidence that city business was being conducted at that conference of mayors?
Yeah, there was, if you watch the video, I believe most of the council members came up on stage at some point, were introduced along with other local elected officials. I believe Bob Lucy was there with the Washoe County Commission. They were introduced in their capacities as elected officials. And so, yeah, there is evidence. It's, I believe, one of the video exhibits.
So you'd say just the mere presence and introduction of council members constitutes city business?
I believe it constitutes their role as an elected official.
Right, but do you think just by the sake of these individuals being there and introducing themselves as council members and mayors of the city of Reno, is that city business in your mind?
Well, your previous question seemed to imply that they have a private capacity, but if they're at a semi-public event being introduced as an elected official, I don't see how that would be considered acting in their private capacity. So therefore, it would be in their official capacity.
Would you disagree with the statement that the mayor at that time was not acting in her private capacity? She was acting as vice president of the mayoral conference, which is a totally different title. Will you disagree with that?
No, I would say that in that case, she's probably commingling the roles, which is a pretty frequent thing for an elected official to do. I don't think just because you enter into an organization called the U.S. Conference of Mayors, your official capacity as mayor gets suspended.
Do you have any legal underpinnings for that?
Objection calls for a legal conclusion.
Sustained.
Okay. So now I know you've already talked about this a little bit, but Dr. Conrad, tell me what your understanding of an NFT is. And I'm going to take notes too, because I barely have an idea of what an NFT is.
Well, we did a story on this a few years ago. I don't have it in front of me, but it's the longhand of NFT is non-fungible token, which means there's a like a digital code or representation of the space whale.
Okay.
Essentially.
And how do you attach value to an NFT? Do you understand that process?
No, I don't understand.
Okay. Okay.
I don't know how I would know that. I mean, or how that's relevant here, but
I'm just wondering what your understanding of an NFT is, because by the very nature of it, well, let me ask a question. Are you aware of whether or not the city was involved in the creation of the NFT?
am I aware if the city was involved in the creation of an NFT? I can't say for certain if it was or was not. The city has been very active in promoting blockchain type technologies. And so it would make sense if they sent out promotions about the mayor's appearance, I believe the mayor's appearance, but definitely they sent out press releases about converting, I believe it was the historical properties, the register onto the blockchain. So
But those are two separate issues, correct?
yes, they are.
So the answer to your question is you're not aware of any involvement the city of Reno had with the creation of the NFT, whether it be the hiring of the artist or anything like that, correct?
I think it's correct that I am not aware of that. Yes.
Okay. Are you aware of if the city of Reno was party to a contract between the artist and the Conference of Mayors?
I don't even know, you're referencing an artist. This is the first I've heard about that, unless it was in that video that was played at the U.S. Conference of Mayors mentioning the artist. So I'm not sure who this artist is.
Okay, well, the NFT is made by an artist. It's an art piece. So there was an agreement between the Conference of Mayors and this artist. So to repeat the question, are you aware of this?
I'm sorry.
Go ahead,
Brian.
Mr. Busby. Go ahead, Mr. Busby.
I'm just like to object for the testimony of counsel.
I understand your objection. I don't think Mr. McElhinney finished his question, so I'd like to hear the full question before I can make a decision on that.
Thank you, Your Honor. Thank you. So to repeat the question, are you aware of any agreement, whether it be a written contract or a verbal contract between the city of Reno and the artist who made this NFT and or the Conference of Mayors?
No, not off the top
And-
of my
and-
head. I'm not aware of that.
And to issue a ruling, I'm going to overrule the objection. Thank you.
Thank you, Your Honor. And again, with the provision of public services, is it your position that the distribution of the NFTs at the Conference of Mayors was a provision of public services by the City of Reno?
The NFT was of the Space Whale, which is a city-owned property. The mayor is obviously an elected official of Reno. So it's my opinion that between those two things, and of course being introduced as the mayor of Reno at this conference, that would be the provision of public service. I think that's fairly clear, yes.
Okay. Would you disagree that the physical Space Whale in City Plaza and the NFT are two different things? Would you disagree with that?
No, I would not disagree with that.
Okay, so would you also agree with the statement that there's no real logical connection other than visual representation between the physical Space Whale and the NFT Space Whale? Does that question make sense?
No, it doesn't.
What connection do you believe the NFT has to the physical Space Whale, if any?
Well, I mean, it sounds like you're asking me to opine on blockchain technologies, and it's not my area of expertise. The NFT of the Space Whale is a digital representation of the city-owned Space Whale. So I don't see how the city can somehow create a Space Whale worth, quote, millions, and then hand that out to, or the mayor hand that out to all the mayors in the United States. I just fail to see how that cannot be considered a city business. I mean, that's a city-owned property. The city used general fund taxpayer dollars to pay for that.
And it's a public art piece. Would you agree with that, Mr. Conrad?
Yes.
I mean, it belongs to the public. Would you agree with that?
Yes.
Okay. And so what I'm hearing, and correct me if I'm wrong, but what I'm hearing you say is there's no real logical distinction between the Space Whale and a creation of an NFT representing the Space Whale. Do I have that right?
No.
Okay. Can you explain it a little better for me?
Again, I don't have expertise in blockchain technologies, but I fail to see how an NFT of the Space Whale is not somehow directly tied to the physical Space Whale.
Well, let's assume. Well, would you disagree with the assertion that the city didn't create the NFT? Do you disagree with that?
I don't have any knowledge of that.
Okay.
Other than what you seem to be implying here.
Okay. Okay. So you agree with the statements that, or you're not aware of any agreement between the city and the NFT creator and or the mayor's conference, correct?
I'm not privy to the details of how the NFT got created.
Okay. Okay, but you have no knowledge of any city involvement, correct?
Well, the city involvement would be the mayor, as I've mentioned a few times now. The mayor somehow getting this NFT, handing out copies, hundreds of copies of it, announcing that publicly in her capacity as mayor at the U.S. Conference of Mayors. I just fail to see how this is not city business.
Bear with me for 1 second here. Oh, okay. Yeah, let's go there. Dr. Conrad, I'm going to have you look at Exhibit 28, which is going to be the affidavit of Ashley Turney.
Mm-hmm. Got it.
Okay, let's see. I'm going to skip down to paragraph 7. and I'm going to read it out loud. Since I was involved with some organizational aspects of the U.S. Conference of Mayors, I knew that the City of Reno was not involved with the creation of the Space Whale NFT, and that the U.S. Conference of Mayors worked directly with a private vendor to create the Space Whale NFT. However, I checked city records for the requested NFT files and determined that the city, I determined that the city did not have a copy of the Space Whale NFT, nor a copy of the agreement between the U.S. Conference of Mayors and the creator of the NFT. Do you doubt the truth of that statement, Dr. Conrad?
Well, there's an old adage in journalism that says if your mother, and I hope my mom's not watching this, but it says if your mother loves you, then to check it out. So my job is to ensure that statements like this are correct. And I have no reason or no basis to determine that, frankly, other than Ashley Turney saying it. Did Ashley have a copy of it at some point? Does she have a copy of it now? Does the mayor have a copy? Does anyone else at the city have a copy? And if the answer to those questions is yes, then of course this appears to be a public record. And I don't know if this affidavit even addresses that.
So have you attempted to get these records elsewhere? For example, the Conference of Mayors, have you either subpoenaed them or requested anything from them at all?
I believe I contacted the U.S. Conference of Mayors when they were here in town, perhaps related to this, or maybe it was the protest that occurred outside one of the gatherings when they were here, and I did not get a response. But no, I have not subpoenaed these records at this point.
Okay,
No.
so no formal efforts have been made to get these records from someplace else, correct?
Correct. I don't see why I would. I mean, it would, to me, I consider them public records from the city. So that's why I requested them.
Well, what the city is claiming, and correct me if I'm wrong, the city is claiming we don't have any of these records. Do you just think that's not true?
I have no basis to determine whether or not that's true.
Okay.
The mayor obviously had a copy or hundreds of copies.
And
City personnel at the U.S. Conference of Mayors working or attending. So, I mean, it seemed pretty...
Again, you dispute that they were not acting in their capacity as representatives of the city. You disagree with that?
I just fail to see how you can separate those roles.
Okay. Your Honor, I have no more questions at this time.
Thank you, Mr. McElhinney. Any redirect?
I'll be very brief, Your Honor. Thank you. Dr. Conrad, can you were asked some questions about the public's interest and how it balances versus the withholding of records. So for request number one, the body cam footage, what's the public's interest in seeing body cam footage?
Well, as you've seen in, particularly in the last 3-4 years, as body cams have become more widespread, what you get is sort of the real unedited and raw version of what actually occurred in an encounter with law enforcement. So by definition, I would say that's public and a matter of public interest. I mean, these are taxpayer funded positions, and the public has a right to know how their money is being spent.
Yeah. Does the public get public have an interest in how the police behave when they're interacting with the public?
Yes, correct. Yes.
Sometimes good, sometimes bad, right?
Correct.
Okay. How about bird scooters? What's the public's interest in knowing who complains about bird scooters?
Well, I think the complaints really determine, the city puts out, happy talking points about the bird scooters and how many trips are saved and the things that the bird scooters are there for, which, I believe are probably good things. I don't have a bird scooter, but I do have my own scooter. It's a interesting form of transportation. But if the city enters into a contract with a private company to provide those services, the public has a right to know how those services are being rendered and if they're successful, and whatever potential negative externalities there may be with that franchisee being here. For example, bird scooters ending up in the river, people getting injured on them. Prior to them being approved here in Reno, we did some research and found that everywhere these types of scooter agreements were being approved by cities, there soon thereafter a cottage industry of personal injury attorneys was cropping up to solicit clientele for people who had been injured on these scooters. So yes, it's very much a matter of public interest.
Okay. And how about the messages of public officials that relate to the provision of public services? What's the public's interest in seeing those messages?
Well, in my reporting, you find those messages, those emails, text messages, and now social media messages are really the way to show people what's really being discussed. The city spends a lot of money on public relations and trying to mold, in my opinion, public perception about what they're doing, but getting the actual things, talking about and looking at the actual things that are going on is often a different story.
Okay. How about NFTs related to the space whale? What's the public's interest in that issue?
So this one's kind of funny because when the space whale was first installed in downtown Reno, the city, when I interviewed at the time, the city arts manager was adamant that this sculpture was A, temporary, and B, being paid for out of room tax dollars. So the space whale then became, in my opinion, controversial because it no longer, it stopped being temporary at some point. And then the city did a complete about face, I believe, last year, and decided to use general fund tax dollars to pay for the space whale. So this is now, as the other council mentioned, a public art piece, literally owned by the public.
All right. Nothing further, Your Honor. Thank you.
Thank you. With that, I think I am ready for argument.
Okay.
Mr. Busby.
Thank you, Your Honor. The Public Records Act requires that any exception to the Public Records Act be narrowly construed. And that applies to any test where there's a balancing of interests as well. And that open records are the rule and non-disclosure is the exception. Now, the record in this matter that we've presented to the court shows that the city's approach to public records is the exact opposite. They broadly construe any exception as a basis to withhold all records. And whenever there's a weighing between the public's interest in disclosure and some kind of right of confidentiality, they err towards confidentiality. Now, under the, Don Ray is an interesting decision because in that case, there was a withholding of police record in a corruption case by the City of Reno. And the court essentially said that, hey, there's no exception in statute that would render these records confidential. But, there are some circumstances in which records may be withheld in response to a public records request. And they are the exact factors that are listed in the affidavit of Deputy Tom Robinson in Exhibit 25. It's basically a copy and paste of the Don Ray decision. And as you've heard, the city's actual, actions when it responds to public records requests isn't to withhold all records when there's an ongoing investigation. It's to do it in some instances and to not do it in others. And that's worrying. The city, if there were portions of the videos that required redaction that could have protected something about an ongoing investigation that could prejudice a jury, taint a witness, etc., they could redact those portions from the video and still disclose it. That would be a narrowly construed exception to the Public Records Act. But what they do is respond citing Donray without much of a substantive explanation, if any, and deny access to the entire record. That's inconsistent with Public Records Act. It's inconsistent with Reno Newspapers v. Gibbons. It's also inconsistent with, the two-prong test under the Clark County School District case as modified by Las Vegas Metro. And I think we've shown that for each of the requests Dr. Conrad made, there's a legitimate public interest in knowing about, what he's requesting. And any privacy interest that's claimed is claimed extremely broadly. And in the matter, as withholding all records or simply not responding. Now, even if the court determines in this case that, hey, maybe some of these exceptions make sense, under the recent decision in Republican Attorney General's Association v. Las Vegas Metro, we would ask that the court require the city to turn those records over, that they be reviewed in camera to determine whether or not the exception claimed actually, makes any sense given the circumstances. Because there's no way Dr. Conrad as a journalist can know that. All Dr. Conrad sees is, a citation to Donray and a denial of the request. Now, turning to, I think that covers, the issues related to request numbers 1, 2, 5, 4, 5, and 6, all the cases in which we discussed Donray. Now, for the other stuff, it's clear that multiple instances of unreasonable delay occurred here. So what does the Public Records Act require? Well, within 5 days, you're supposed to indicate in response how you're going to respond to the record request. You either provide the records or you say when you're going to. Now, the record shows with Dr. Conrad that he faces continual delays. And those delays, in our estimation, are unreasonable. For several of the requests listed herein, they weren't responded to until after we filed the suit, which is tantamount to, a victory on his behalf before the court in our minds. There's also the issue of closing public records requests, as in request set number 1 and 2. Now, Dr. Conrad requests the body cam footage. There's a claim of confidentiality and the request is simply closed. So Dr. Conrad has no idea, when the claimed investigation is going to end. He's forced with essentially making the same request repeatedly, trying to obtain copies of the records. Now, that's contrary to the provisions of the Public Records Act that require them to say when the record will become available. They can't just close the request and then force a journalist to repeatedly make the same request over and over again. Turning to the issues related to the sought communications with Councilman Reese, that I'm intimately familiar with that line of cases because Comstock Residents Association was my case. And in that case, what happened was Lyon County commissioners were posting their personal email addresses on the county website and using those to communicate with constituents and to conduct county business. Now, when Mr. Reese made the public statement in Exhibit 11 that he was communicating, this is a 24/7 job. I'm out there talking to people about my job all the time. That's prima facie evidence that he's using these platforms as a method to communicate with constituents and others about the provision of public services. And that's when you're acting in your capacity as a city council person, your communications belong to the public. They're public records under the Public Records Act. Mr. Reese may very well have private communications of a personal nature that have nothing to do with his role as a city council person, but we disclosed at least 2 instances here where he was clearly communicating about city business with constituents, and these records weren't turned over. In addition, there was a sworn affidavit that was filed with the court that said that none of these communications existed. Now, that's clearly not the case here. I don't think this is a question of, a philosophical difference between what's personal and what's not. He's talking to Natalie Handler about bird scooters. Bird scooters is a political issue. She's asking what he's going to do in his capacity as a city councilor about these issues. Nick Shepak, the declaration of Nick Shepak is a similar thing. He's talking about legislative action, what the ACLU is doing, what issues with municipal court judges, issues with municipal court in the city of Reno. These aren't personal communications. This is a city business here we're talking about. Now, in the Comstock Residents Association case, what the court ultimately determined should happen in a case where a person uses a personal device or account for the provision of public services, the court orders them to do a good faith review, subject to review by counsel of their communications, and to determine whether or not such records exist. And if so, they be disclosed. Now, that's what happened at the end of the day in the Comstock Residents Association case. The facts in this case aren't markedly different. Instead of posting your email and saying you're using it on the Lyon County website as a contact, he's basically saying that he's using social media in the same way. These cases are quite closely analogous. And one more thing on the body cam footage issue. The legislature went out of its way when it passed the body worn camera statute, NRS 289-830, to say that these records are public records. Now, withholding them in their entirety from the public is plain. It's not only inconsistent with the Public Records Act, it's inconsistent with the express purpose of the statute. And I think that if they're able to withhold records for an extended period of time after a dramatic event, like a police shooting or something like that, where in other cases in a police shooting, it's immediately released. The public has legitimate questions about why in some cases is the city, upfront with everything, posts the issue on YouTube, and then in others, there's this silence and a claim of confidentiality. I'm not saying that the city, is expressly. It creates a perception that the city can shape events about what's happening and whether or not to release records in a discretionary matter, rather than what's required under the law, which is the Public Records Act. And that's deeply concerning because the whole point of the Public Records Act is to provide a mechanism for accountability. So people can make up their own minds about whether police conduct in this instance or that instance is heroic or not. Oftentimes it is. This isn't a criticism of the police or the Reno Police Department, but when records are withheld in this manner, it creates suspicion, especially when there's no uniform policy for how that occurs. Now, if the court has any questions for me on any of these points of law, I'm glad to elaborate, but that's essentially our argument, Your Honor.
Thank you. I would like your, tell me the name of the case again on Republican Convention of Attorney Generals, I think.
Oh, that was, Republican Attorney Generals Association v. Las Vegas Metro, and that's at 458 P3D 333. And in that case, when there's a NPRA petition before a court and there's a dispute of fact about whether there's a legitimate privacy interest claimed or invocation of Donray, that the court should examine the records themselves to determine whether or not they were properly withheld. And that Justice Stiglitz authored this opinion very recently, and I think it makes a lot of sense because everyone on our side is in the dark about what these records actually show. It's hard for us to show up on a petition for writ of mandamus saying, hey, we need these records. We don't really, we don't know what they show. There's a claim that they're being withheld properly. Disputing that would require us to know the contents. So if the court could review those documents in accordance with RAGA or the videos, determine whether the invocation makes sense under the circumstances, we would ask that it do so.
Thank you, Mr. Busby. And with that request, I just want you to note that would delay any final decision on this case if I were to review those records.
Yeah, indeed, Your Honor. And it's our position that that would only, that decision becomes applicable only where the court would otherwise rule that we're not entitled to receive the records. So.
Right. And I'm not at that place yet. Yeah, exactly. Okay. Thank you.
Thank you, Your Honor.
Mr. McElhinney.
Thank you, Your Honor. I'd like to start out talking about Don Ray, and I'd like to bring the court's attention to Petitioner's Exhibit 19, which is, I believe, Mr. Conrad's previous case that was discussed. Page 7, lines 13 through 15, this court cites the Don Ray as the proper method to accomplish his balancing test. So opposing counsel's doubt as to whether Don Ray covers the issues that we're talking about, I think that's made clear by the court's order in Mr. Conrad's previous case. Moving on to the assertion or the concept of the Public Records Act, that everything is a public record and everything should be turned over. It's interesting, Mr. Busby mentioned the Republican Attorney General's Association case. And I will quote straight from that case: "The obligation to disclose is not without limits. In NRS 239-010 subsection 1, the NPRA yields to more than 400 explicitly named statutes, many of which prohibit the disclosure of public records that contain confidential juvenile justice information, including 62H.025 for confidential justice." And I'd also like to draw the court's attention to NRS 289.830, which renders body cam footage confidential as a matter of law. So that is an example of one of those statutes that limits the, or that tempers the public records release. I'm sorry, 239.010, apologies, correction.
So I'm sorry, Mr. McElhinney, 231.010?
239.010.
Thank you.
So, point being, Your Honor, while the Public Records Act does anticipate everything being a public record and everything being subject to release to the public, it is clearly subject to not only statutes, but case law, which contain balancing tests, considerations of privacy, and as well as the ongoing investigations. And I think this is a nice segue into the individual requests. So requests number 1 and 2 were denied based on Don Ray because these cases were still being actively investigated. And the position, well, the case law's position is that this has the potential to jeopardize ongoing investigations. And I believe the court in Clark County discussed, no, I'm sorry, it was Don Ray. They're talking about potential versus actual litigation. And in the cases of request number 1 and 2, these weren't potential investigations, they were actual ongoing investigations, which I submit serves as a bar to release until those investigations are finished. Moving on to another point made about these, there is nothing in the statute, nothing in the public record statute that obligates the City of Reno to keep requests open. Not only is there no requirement in the NRS to have that happen, but permitting that to happen, you know, rather than closing requests, for example, for a request on body cam footage that's still under active investigation is, I'm sorry, I lost my train of thought there, Your Honor. This is, these are common sense applications of the rule, Your Honor. If we're talking about anticipated litigation, nothing's happening yet, then it would be a different story. In either of these two cases, they were ongoing investigations, actual investigations, and that serves as a reason for denial in and of itself, I believe. City was in compliance because we cited the Clark County case, and it's the city's position that for many reasons, this is just one of them. The defendant's interest in a fair trial does not outweigh the public, or outweighs the public interest in release. And it's not just the defendant's right to a fair trial, it's the investigative techniques of the police, potential witnesses, future jury selection, stuff like that. I mean, these investigations are sacrosanct in that way, and they have to be protected from, denying a defendant due process. And again, NRS 239 does not mandate notification when an investigation is closed, nor does it mandate reopening a request of our own accord. The burden or the onus is on the records requester to keep up with the status of his request. And if his request has been closed, he needs to reopen it of his own accord. The city is under no obligation to do that, legal or otherwise. Okay, request numbers and request numbers 3, 4, and 8. For the court certification, these were all provided to Dr. Conrad. Some were delayed, some were outside the scope of time that we predicted. But in all cases, we complied with 239-01071C, which is the explanation in writing for why we aren't able to provide those records at the time, and an estimate for when we will be able to provide those records. And what I kept hearing from Mr. Conrad is he simply was unhappy with the delay and unhappy with the procedures, but this is the way it works in the records department, Your Honor. As to requests 4 and 8, as stated or as testified to by Dr. Conrad, the city asked the requester to narrowly tailor his request. Now, this was coupled with an email log that was provided to the requester so that he could go through and try to narrowly tailor this request. He refused to do that on 2 occasions for requests in 4 and 8. So an argument could be made that much of this delay was due to the non-cooperation of Dr. Conrad himself and the violation of statute, frankly, where he refused to make reasonable efforts to narrowly tailor his request to, in an effort to get it to him in a more expeditious fashion. Request number 3, I understand the issue, Your Honor. The charge that Dr. Conrad was given doesn't appear on the fee schedule, but regardless, he testified he was not out of pocket for any of these requests, so he ultimately did not have to pay any money, and therefore I think that issue is moot. It was an oversight on the part of the City of Reno, but the fact that he didn't actually pay any money tells me he didn't have any damages, and he wasn't wronged in that fashion, and there was no violation of records law, Chapter 239. Okay, request number 5, city redacted based on Bradshaw, which I continue to submit, Your Honor, was proper. We don't owe record requesters lengthy explanations for why they can't get these records. The law only obligates us to cite to either the statute or the case law, which is the basis for our denial. Redacting individual complainers' names, I know there was some inconsistent treatment on that, but from a privacy perspective, the concern is if we provide records to individuals with people's names on them or any kind of identifying information, it has the potential to create a chilling effect, and people will stop making complaints because they don't want to be identified. And I think that's a very important consideration that we need to make. If it's a different story if the person wishes to be identified, and I think that that is it's a separate issue. But if the person agrees to be identified, it's fine. But if for example, with these bird scooters, if Dr. Conrad had gotten 20 or 30 emails with people's names on it that didn't want their information released, again, that's going to create a chilling effect. It's going to make them less likely to complain in the first place and less likely to identify themselves so they can serve as witnesses for whatever they're complaining about. And again, privacy interests in this regard outweigh the public interest in receiving the records, and the disclosure of the complainers' names doesn't advance any significant public interest not already advanced by the release of the records themselves. Okay, request number 6. According to according to the facts and according to Dr. Conrad's testimony today, there should be no issue with request number 6. It was timely received, unredacted, and so I don't see any problem with request number 6 whatsoever. Request number 7, again, records were received on time and free of charge. Again, with the omission on the fee schedule, that was just an oversight. But again, he did not have to pay this money and therefore wasn't wronged in that fashion. Okay, request number 9, Council Member Reese's social media post. It's the position of the city that these messages do not rise to the level of the provision of public service as described in Blackjack Building. The petitioner didn't mention it today, but in his moving papers, he cites to a case, Garnier. I don't have the full case name. This case is an opposite. It doesn't deal with public records. In fact, the court specifically mentions in that order that their decision is limited to the circumstances of that case and cannot be extended anywhere else up to and including public records. Finally, as guided by Comstock, the city followed protocol regarding provisions of public service concerning the council members' personal devices and media accounts. Again, Your Honor, I do not think these messages rise to the level of provisions of public service. I think these are introductory discussions, sometimes just a little banter back and forth that is not deliberation, it's not deciding, it's not necessarily discussing issues when they're up for a vote. And for example, the discussions on the bird scooter, I believe that had already passed, and these were complaints about the bird scooters, you know, that they were being left in bad places. So there was no discussion of the bird scooter coming up to vote. This was just an incidental conversation about bird scooters, which again, I submit does not rise to the level of provisions of public service. Similarly, request number 10, I submit that the Conference of Mayors, Mayor Sheevy's role at that Conference of Mayors not only did not rise to the level of provision of public services, but also the mayor was not acting in her capacity as mayor of the city of Reno. She may have been introduced as the mayor of city of Reno, but she was not taking any actions as a mayor. She wasn't doing any mayoral duties on behalf of the city. She wasn't in a city council meeting. This was a private event organized by not the city of Reno. The city of Reno had no involvement in the creation of the NFT. The city of Reno was not subject to any contract, any type of agreement with the artist, the vendor, or the mayoral board. And the mayor was simply acting in her role as vice president of this event. There were no deliberations taking place. There was no city business under discussion. And to say that a digital representation of a piece of public art being distributed to, you know, third parties outside the scope of her role as mayor does not rise to this level. It does not rise to the level of provision of public services. And the fact that the city is not involved, I believe, and I submit, bears that out. The city just had no role in this whatsoever, financial, contractual. It simply involved members of or employees of the city of Reno, elected officials of the city of Reno. So that being said, I think that's all I have, Your Honor.
Thank you very much. Mr. Busby, anything in conclusion?
Just a few brief points, Your Honor. I just want to point out my friend on the other side addressed NRS 239-0107, and I think that's, you know, a focal point of the disagreement we have in this case. And if you look at that statute, what it addresses is what a government is supposed to do if it can't comply with a public records request within 5 days. So number one, it's supposed to provide the person of notice of that fact and tell them when the date and time at which the record will become available. Now, we've argued that, you know, the city shouldn't close records requests when it invokes dawn rate. And this is the basis for that, that conclusion in statute, where specifically they have to state in writing an explanation of the reason the book of record is not available, and a date and time after which the government entity reasonably believes the public record will be available for the person to inspect or copy, or after which a copy of the public book of record will be available to the person. Now, so how could the city deal with this as a practical matter? You know, they could respond saying, this investigation is likely to be concluded by this date and time. That would arguably comply with the statute, but that's not what they do. They just say, Don Ray, case closed. And so as a journalist, you're left in the dark about, what to do next. I mean, and I think my friend on the other side basically admitted that he just is in a position where he has to continually make these records requests. And in our estimation, that's inconsistent with the statute. Now, turning to the duty to focus the request, that's subsection 2 of provision C of that statute. And what that says is they have to make the city or the responding entity has to make a reasonable effort to assist the requester to focus the request in such a manner as to maximize the likelihood the requester will be able to inspect the records as expeditiously as possible. Now, Dr. Conrad requests emails. In this instance, it was the bird scooter emails. And he gets back a log with presumably titles of the emails. And he says, well, I don't know what these emails say. They're on the right subject, so they're responsive, so I want them all. There's actually no duty on his part under the statute to narrow his request, especially when all of the records indicated in the log are directly responsive. They're the records he's looking for. Turning to the issues related to the NFT, I mean, we just essentially disagree with the assertion of fact that the mayor is acting outside the scope of her duties as mayor when she's acting as the mayor at the conference of mayors. That's, I think, a judgment call that the court has to make on the issue of fact. And the mayor isn't here testifying to that. So, just by virtue of the language used, it's hard for us to see how she could step outside of the role in, acting as the mayor of the city of Reno at the conference of mayors. As to the NFT itself, Dr. Conrad was left in a position where he's, the city owns this statute. These things of value, presumably, were created by someone and distributed by the mayor herself at this meeting. Now he's saying, well, what are these things? I want a copy of it. And, the response we think is inconsistent with the requirements of the Public Records Act because the mayor was acting in her capacity as mayor when this happened. The social media messages issue, my friend on the other side, I think, tried to turn the issue into one of whether or not Councilmember Reese was deliberating towards a decision, which I think is language from the open meeting law. But the Public Records Act is much, much broader. And the provision of public services, I think the Comstock Residents Association court concluded that means, anything within the scope of their duties as a public official. And when you're discussing issues of import to the city with constituents, they're talking to you because you're a member of the city council. And that's in the content of the messages admitted by the court clearly show that. It's troubling to us that there was a blank denial of that any of these records exists in Councilmember Reese's affidavit. That was inconsistent with what he said publicly on Twitter in Exhibit 11. And then we went out and found, a few of these actual messages. And that's in a normal context, that's the kind of action before a court that can lead to, orders to show cause. It's a serious matter. It's a representation to the court that appears to just not be accurate. And with that, we just pray that the court grant the relief requested in the petition. We think that the facts show, especially the reference to the prior case, this isn't an isolated incident. Dr. Conrad has been having continuing and longstanding issues with the City of Reno related to public records requests. He was awarded attorney's fees. There were Judge Draculich found there was a violation in a prior case. This isn't, the first rodeo. And some of these violations appear, to be willful, especially the one involving Councilmember Reese, and the statement by Officer Donaldson that they never disclose footage, body cam footage, while there's an investigation pending. That just seems to be inconsistent with the reality of the situation. And with that, submit the matter for the court's judgment and ask that all the exhibits be entered into the record.
Thank you. I think, I don't know that we addressed all of the exhibits as we were going through questioning and argument. But I will, unless there's objection, Mr. McElhinney, to admitting all of the exhibits as submitted.
No, Your Honor, so long as they're qualified as we previously discussed, exhibits 22 and 27, I believe.
I would agree with that, yes. So they will be admitted with the qualification as to, again, 21 and 22, I believe. Okay, so.
And I have no objection to that, Your Honor.
All right, thank you very much. With that, the court will take it on submission and we'll get an order out to you as soon as we can. Thank you all very much for your time.
Thank you for your
Appreciate
time.
it.
Thank you, Judge.